Welcome to part two of contract law. In this session, I will cover intention to create a legal agreement and consideration. I will take you through the law for your assessment objective 1 marks, and we will look at application for assessment objective 2, and then we will also go through some key evaluation points for assessment objective 3. As you know, with the OCR A level, formation, all elements of formation are subject to evaluation. So they could be essay questions on the exam. Remember, you have one essay question every year. You do not get a choice. So it's really important that you prepare for each of those elements coming up as a potential essay. In the last exam at the time of recording, 2022 paper, consideration was the essay question. Okay, so what do we mean by intention to create a legal agreement? The courts look at what they believe or make a decision on what they believe the state of mind of the parties were at the time of creating the agreement to decide whether it should be recognised legally or not. And to do this, they start by looking at the nature of the agreement. So they split all agreements into two arrangements. These are social and domestic arrangements, which are agreements made between family and friends, and then commercial arrangements, which are agreements made in business. If you think back to one of the key cases for offer, Carlyle against Carbolic Smokeball Company, how was intent evidenced in Carlyle? Can you think about on the facts, what did the company do to show that they were serious about the offer? Because, of course, in this case, albeit back in the 1800s, the court decided that Carbolic Smokeball's advert was actually an offer, what we call a unilateral offer, open to anybody to accept via conduct. And the intent, the court decided, was evidenced by their depositing of £1,000 into a bank to show that they were serious about paying the reward. You could argue that that was the consideration, and the court said, used the words intent and consideration. But it's interesting that we can often evidence intention through the consideration given, so a deposit or the value of the contract. So it's worth thinking about the overlap of those two elements there. Okay, let's look at social and domestic arrangements first and how the courts navigate their way through those disputes. Okay, so the presumption, so the starting point is that these types of agreements will not be legally binding. So we have two kind of key cases, and the first case I'll talk to you about is old, over 100 years old, Balfour against Balfour. So this was a dispute between a husband and wife. Now, I mean, over 100 years ago, you're all probably aware that wives, women as part of relationships did not work. You know, their role was in the home, they raised children. So in this case, we had a husband who was sent away for work and promised to send his wife money back, £30 a week, which of course back then would have been a lot more money than it is now, £30 a week for maintenance. When he failed to do this, she ended up suing him for breach of contract. And the court in that case actually held that there was no intention to create a legal agreement. What they said was because of their relationship, because they were a family, so they weren't separated or divorced, and it was what they classed as a domestic arrangement, there was no intention to create a legally binding agreement there. I mean, you might argue that that's quite unfair because, of course, the wife wouldn't have been in a position necessarily to work herself and earn that money. So perhaps the courts could have taken a different approach in that case. And actually, maybe it's slightly outdated now because, of course, you know, many relationships and working situations are different. We've kind of developed a lot more and moved on from that kind of family setup, if you like. So if we go forward to 1971, the case of Mr. Merritt and Mrs. Merritt. So this was a case where the parties were actually separating. So they were married, but they were separating. And Mr. Merritt told his wife that she could have the family home if she finished paying the mortgage. So she kind of upheld her part of the agreement, but then he decided that he wanted a share in that home. So he wanted that either the home itself or money from the home. So he went back on their agreement and she sued him. And in that case, the court actually found in her favour and said there was intention to create a legal agreement. So although given these were Court of Appeal cases and given that they had the earlier principle in Balfour based on husband and wife holding that there was no intention, that was a technically abiding principle on them and they should have followed it in Merritt. But they actually distinguished from this precedent because they decided that the facts were different and so they shouldn't follow it. It wasn't relevant to the current case. So they held there was intention to create a legal agreement there and upheld the original agreement between Mr. and Mrs. Merritt, which of course you may feel is fair. But of course, Balfour is not overruled. They distinguished from it. So it's still good law in certain situations. We may still feel that needs overruling at some point. Now, at the bottom, my third bullet point, how does Radmarsha and Granatino 2010 UK Supreme Court case compare? So for those of you who don't know about this case, it was a landmark case decided, overseen by Lady Hale at the time. And this was a case of a husband and wife who were trying to uphold a prenuptial agreement. So this was an agreement that they'd made before marriage that they would protect. It has the effect of protecting assets. It's very much an overseas thing. It's not something that we've ever really recognised in our jurisdiction before, because as courts, and I feel over the last 10 years we're starting to move on from this, but traditionally we've always kind of upheld those marital values and views of sharing everything 50-50 between parties. So to then try and uphold a prenuptial agreement which says, this is my share and that's yours, and not share equally, kind of goes against the traditional views of the court, should we say. So it was quite surprising in this case where the Supreme Court upheld the terms of the prenuptial agreement, and it was actually the wife in that case that was from a rich family abroad, and she had inheritance that she wanted to protect and didn't want to share on divorce. So the courts upheld that and actually said in their judgment that prenuptial agreements can be given some weighting now when dividing assets upon divorce. Now, Lady Hale in the Supreme Court, who of course went on to become president, and Baroness Hale, she dissented from that judgment. So she disagreed with the majority in this decision because she said that she felt that marriage should still be equal, regardless of a person's background or how much they feel they've contributed to the marriage. So if you read the judgment, if you go onto the Supreme Court website, there's a press summary and there's the judgment of this case. She does talk a little bit about her view, but the majority agreed that this should be upheld. Now, what we kind of see, I guess, with this case is a move forward, making perhaps social and domestic arrangements more formal in that type of situation. So you can take from this that if parties separate or if they divorce, then the arrangement actually becomes, or agreements through the arrangement become pretty much legally binding and upheld by courts. So the courts decide that there is intention there to create legal agreement. So we have a bit of a departing from the original presumption there, perhaps a bit of development from the earliest case of Balfour. Okay, what will, based on precedent, what will change the presumption is the closeness of the parties, and I suppose you could evidence that from Merritt and Radmarsha as well, because if parties are intending to divorce or they are separated, then of course they're not going to be as close anymore. So anything they decide is probably has some intention to it to be more formal. But also if money changes hands, and if third parties are part of an arrangement or an agreement as well, then the courts have the ability to depart from their original view that there will be no intent. Okay. Um, so there are two cases that I've put here just to evidence that, but there are lots of cases out there, and it may be that if you have different teachers, they might use different examples. And of course, your textbook may refer to different examples as well, but I've used these two here. I just think the facts are quite straightforward. So you've got the first case, Jones and Padavatten. So this was where a mother persuaded her daughter to move to England and study for the bar. So she was, destined to be a barrister, if you like, and promised to allow her to stay in her house. When the daughter failed the bar, her mother evicted her. I think that's a really bizarre case in itself, but there we go. Those are the facts. Now, when the daughter tried to uphold the original agreement, so presumably sued her mother for breach of contract, the courts held this not to be binding because they said that their closeness at the time of making the arrangement meant that they couldn't have been intention to create a legal agreement. Um, so the nature of the parties at the time is really important. And as I say, that's the same as merit and merit there. Look at Simpkins and Pays. This is where we have evidence of the presumption being rebutted, if you like. So if you rebut a presumption, you're basically you're disproving it, if you like. You're moving away from that original starting point. So it's a legal term. Make sure you use it in a scenario when you're talking about the if the original presumption has changed. Make sure you use that wording. So Simpkins and Pays. So this was three parties, if you like, to an agreement. So a grandmother and her granddaughter, and then a lodger. So if you were looking at the relationship between a grandmother and a granddaughter living together, you would probably say, okay, this is a true social domestic arrangement. They're probably close. But the fact that there was a lodger as well just makes this perhaps a little bit more formal. So all three agreed to enter into competitions. They entered in the grandmother's name and paid equal shares of the entry money. So they all entered together using money to do so. Now, they won £250, but of course, the grandmother, because it was in her name, was paid that money. And if we think back to the 50s, that was a lot of money back then. But she refused to share. So the granddaughter and the lodger sued her, and the court upheld that as an agreement and made the grandmother pay the shares to the other two. So you see, although on the face of it, initially this might be considered a social domestic arrangement, the fact that money's involved and there's a third party meant that we could rebut this presumption and find that intention exists. Okay, so moving on to the other type of arrangement, commercial or business, the presumption will be that these arrangements are legally binding. So, of course, if we look at why social and domestic arrangements are not legally binding, it's because of the closeness of the parties. So we can presume that this is because the parties would not be deemed to be close socially or domestically. Okay, so on the face of it, these types of arrangements are more formal and therefore intention should be presumed. But remember, presumptions can be rebutted. And an example of this is from Jones and Vernon's Pools, an old case again. I mean, a lot of contract law principles are based on really old cases, and they are still very much relevant now. There are other cases that illustrate a similar point. You might have learned about Rose and Frank and Compton. So don't feel that you have to use these exact cases. But in this case, wording actually rebutted the presumption. So Mr. Jones claimed he had a winning football coupon from the Pools company. So he'd been betting basically. but on the back it said that the transaction was binding in honour only. So it was intended to be a bit of fun, if you like. It wasn't intended to be a proper kind of betting transaction. So when he tried to sue for what he believed were his winnings, he failed because the courts held that there was no intention to create a legal agreement there between him and that business. If we look at an alternative example, I really like this case, McGowan against Radio Buxton. If you Google this, and I've put a link there, there is an article about this case, really interesting case. So this was a lady who entered a radio competition, and the prize being a Renault Clio car. She won and was presented with not a car, but a 4-inch scale model of a car. And of course, she was really disappointed and angry, so she sued the radio station. And the radio argued that it was just a prank. They didn't intend to create a legal agreement between their competitors and themselves. But the courts found otherwise, and they said that Mrs. McGowan entered in good faith and had no reason to believe that the competition would have been a hoax or would have been a joke or a prank, if you like. So the radio company was ordered to pay her £8,000, which at that time was the equivalent of the cost of a brand new Renault Clio car. So they held that was a legally binding agreement there. So really interesting case. Please do look it up. So you've got Jones for the intention being rebutted, and then you've got McGowan for the upholding of the agreement. Okay, so let's have a go at applying. There aren't that many past paper questions on intention if you look back through the years. But I've got a couple of smaller questions here that you could just have a look at. And then there's also larger questions where you can have a go at. So the structure that I would adopt, I've got on the right-hand side at the top. So I'd identify the relationship first. Is it social, domestic, or commercial? And then explain the presumption. So is there initially going to be presumed to have intent or no intent? And then based on the facts, explain whether the presumption could be rebutted or not, and conclude whether you believe there's intent or not finally. So please have a read of these and then have a think. In one, there's more likely to be intent. In the other, there would not, if that helps. Okay, so hopefully you've reached the conclusion that perhaps there would be intent in scenario 1 and then maybe no intent in scenario 2. So if we look at scenario 1, the relationship perhaps on the face of it could be social and domestic because you've got 3 students sharing a flat. But then of course you have an agreement to buy milk and a fine system of 50p. So it could be that based on money and based on the 3 of them in an agreement, that the presumption is rebutted. Similarly to the Simpkins and Pays contract, so you may conclude that therefore there is intention here. The second one, you may agree that this is also a social and domestic arrangement, and perhaps the presumption would not be rebutted, similarly to the case of Jones and Padavatten. So you may conclude that there is no intention here to create a legal agreement. Okay, so on this slide, I've got a summary for the key points for you. Remember, for OCR, you are marked out of 8 for assessment objective 1. So once I've put these up, please do take some time to write them out and then move on. So there's some key principles there. And as always, you get marks from explaining. Let's not just throw cases in brackets. Let's explain the relevance. You don't have to write lengthily about facts. Obviously, cases can help us to make decisions in scenarios like I did on the previous slide. I used a case for each of those to evidence or back up my decision, if you like. But Also, you can use cases to explain principles as well, as I've done here. So I hope that this summary helps you. Before we go on to consideration, I thought I would set out some key evaluation points, and I've numbered them just to help you with a bit of structure for a potential essay. So typical exam questions in contract law could ask you about the clarity, the unfairness, the need of reform for the rules in a particular area. And that would be a good kind of starting point for each of your formation elements. How clear, how consistent, how fair, how outdated are the potential rules? You could even plan these in a table, clear versus unclear or fair versus unfair, that type of thing. So I've got kind of 5 points here to get you thinking about these evaluation points. With any essay, I would start by explaining the rules and then go on to evaluate them. I just feel that's a clearer structure to adopt. Of course, if you feel more confident to be able to explain principles within evaluation points, that is also fine. Just remember, you can't be double credited for marks. So if you explain a principle, you will be given AO1 marks for that. Whereas if you use it to illustrate an issue, then you will be given AO3. So to make sure you get double credit for that, if you like, make sure you clearly explain and then you use it in an evaluation point to illustrate separately. I hope that makes sense. So how clear are the rules on intent? So my first paragraph would be about the family and social arrangements. Potentially the rules can be seen as outdated, particularly when we look at the Balfour decision. But perhaps we have movement in updates when you look at decisions like Radmarsha with the prenuptial agreements. So perhaps we are moving in the right direction and recognising that not all marital arrangements will not have intent attached to them. Okay. The second point could be, are decisions on rebuttals consistent? Because we know that the courts will make decisions in rebutting social and domestic presumptions based on who is party to the agreement, so if there's a third party, or whether money's changed hands. But of course, in Balfour, there was money agreed, wasn't there, £30 a week, and the courts did not rebut their decision, the presumption. So it's not always going to be consistent. It really comes down to whoever's deciding at the time and their perspective. So it's what we call subjective, which makes the rule potentially unclear and inconsistently applied. Moving on to the commercial arrangements, of course, the presumption that there is intent gives certainty and clarity for businesses. They know if they make a contract, make an agreement, then that will pretty much is almost guaranteed to be upheld in courts if anything goes wrong. But if we move to the fourth point, is it fair to rebut the commercial presumption based on wording? Perhaps this disadvantages the individual. If you look at the Jones and Vernon Paul's case, that individual perhaps thought that he was owed that money through the transaction. And you could also argue, is it always going to be clear when wording rebuts a presumption, particularly if you are an individual and the wording is quite complex? There may not be that understanding, which can of course disadvantage and lead to a lack of clarity. And then just a kind of general point, fifthly, do we need intention as an element at all? Because often contracts rely on consideration as proof. We need to look at Carlisle for that. They evidenced intention by Cobblick Smokeball depositing the £1,000 into the bank. So, that's consideration, is it not? Not intention. The two kind of can go together. So do we need intent is a potential consideration there. And then, of course, finish your essay with an overall conclusion. Are the rules clear or not? You may have a balanced conclusion, which is fine, and then a potential suggestion for reform as well. A kind of overarching reform is always in areas of contract law that haven't been put into legislation. Let's codify and put these rules into one place. Let's formally update the social and domestic presumption rules as well. Okay, so we're going to move on to consideration, our fourth element of formation, and it is essentially the value to the contract. Okay, so it's a bit bigger, this area. Um, Consideration could be defined in the case of Curry as a right, interest, or benefit versus the detriment, loss, or responsibility between parties. In essence, for a contract to be upheld, consideration has to work both ways. So both parties have to give something to the other, or promise something to the other, should we say, and also have to give up something. So we use a really basic example of: you go into a shop to buy a sandwich, you're giving up money in exchange for that sandwich. The shop is giving up the sandwich in exchange for money. So we have to identify that consideration has been given from both ends. If not, then that transaction is probably going to be a gift, which would not be contractually enforceable. Okay, so consideration is the value that each party to a contract promised to give each other in exchange for performing. So commonly, this is going to be goods or services. If it's something quantifiable, then it's quite easily established. You know, sandwich in exchange for money is an easily established consideration or value to a contract there. It can be proof that an agreement exists, because really, when we look at offer, acceptance, and intention, they're not concrete um, elements. Whereas if you've got money, if you've got goods or services, they are tangible things that can be evidence here. So a lot of contracts hinge on the value. So the terms you can use here, especially if you have a consideration scenario, is the promisor and the promisee. So we move from, when we're looking at offer and acceptance, the offeror, offeree, to now the promisor, the promisee. The promise in exchange for goods and services, for example, payment. Okay, so have a look at the case of Chappelle and Nestle. Nestle being obviously the company that manufactures chocolate. So Nestle offered its customers to purchase a recording of a song at a lower cost if they sent in some of their chocolate bar wrappers. In this case, the consideration was held to have been the chocolate bar wrappers. That was deemed to be sufficient enough to uphold this as a contract with value. So consideration can be really small and nominal as long as it's accepted between the parties. What we can take from this case is that there's no minimal value. And I mean, potentially you could see businesses kind of exploiting this, couldn't you? They can place a really nominal value, you know, a penny or something, on a contract in order to make it enforceable and not be seen as a gift. What can be quite difficult is if the consideration is not something quantifiable, if it's something that we can't really see, if you like. And there are two cases that illustrate this really nicely. You've got Ward and Byam from 1956, and you've also got White and Blewett, which was 3 years earlier. Now, in Ward and Byam, this was basically a case about maintenance payments, or what we would call, or what we would enforce now through the Child Support Agency, CSA payments for the raising of children. So this was a father and mother that weren't living together, and the father had agreed to pay the mother money for her to raise their daughter. What the daughter would be called at the time illegitimate, because the father and mother weren't married. Of course, that doesn't, really, that isn't really discussed or used as a term in society anymore. But the father stopped paying the mother, and when she sued him, he argued that she wasn't giving anything as consideration in exchange for his money. But luckily, the courts upheld the agreement, because they said what she was doing was raising their daughter, giving her love, giving her affection, making sure she was safe, and that warranted the payment. And as I say, now we see that legally enforced through the Child Support Agency. I believe that came in 1991 and in the early 90s, and that can be enforced now where parents aren't receiving maintenance payments for the raising of their children if they've separated, that can be enforced now. So, we could argue that this case was kind of the reason, or certainly contributed to that formalising. But we can contrast that with White and Blewett, where a son was promised money from his father if he stopped complaining about being unfairly treated in comparison to his siblings. When the father died, the son tried to enforce that money from the father's estate, and actually he was refused the payment. It was held that he hadn't actually given anything of consideration for that money. The fact that he'd stopped complaining, as requested by his father, was not adequate consideration. So here we go. We have love and affection being classed as consideration, adequate value for the exchange of payment, but we then have not complaining as being held not to be given any consideration. A case that you could look up, which is quite interesting, I think, it is a American case, so it is persuasive on our system, not binding. Is the case of Hamer and Sidway, so Hamer v Sidway, Sidway. And this was a case where a son had promised his uncle that he would give up gambling, smoking, and drinking alcohol until he was 21, which of course is the legal age in the States, in exchange for his uncle giving him £5,000. So that was like a promise between them. So, I mean, the uncle was the promisor. I will give you £5,000 if you give these things up. The nephew held up his end of the bargain, and then his uncle didn't pay him. The nephew successfully sued for that money. So it kind of shows you that not everything, not all consideration is going to be money or a good or a service. It could be giving up something. So just an interesting case that you could use as well. But I do emphasise it is persuasive. Okay, so that's the slide about value. Let's move on. So we have the timing of consideration next, when consideration can be enforced. So the general rule is that consideration that needs to be given either at the time of making the agreement or after the agreement's been made. And in a way, this seems like a really kind of obvious and common sense principle, because I use the example with my students in class. You wouldn't just go into Costa Coffee and start working, go behind the till and start pouring coffee and then expect to be paid. Usually, if you expect to be paid for something, you have that agreement first and then you carry out the work, if that makes sense. So the case of Ree McArdle illustrates this principle quite nicely. Although you could argue that this decision is a little bit unfair on Mrs. McArdle. So the reason why this case is called Ree McArdle is because this was an inheritance dispute. It was a money dispute around the estate, McArdle estate, if you like. So Mrs. McArdle carried out repairs on a bungalow that formed part of her husband's estate. So he had died, and she wanted to carry out the repairs to obviously increase its value upon sale. So she was due to inherit a share of that bungalow, but also his other siblings too afterwards. So the siblings, or his siblings, agreed to pay her for the work that she'd carried out, so £480 back then for the work, but they never did pay her. And she actually sued them for the money, but the court did not uphold the payment, because the promise to pay came after the consideration had been performed. So really what she should have done was talk to them about the repairs first and make the agreement and then carry out the work afterwards. So she'd already carried out her consideration before the agreement. Okay. There are two exceptions to this, albeit strict rule. So if payment is implied, let's say there's a service being performed, then that may be upheld, even if you haven't made the agreement first of all. And I mean, this is a really old case, but Lampley and Braithwaite, if you look at this case, this was where a solicitor, Mr. Lampley, carried out a service for Mr. Braithwaite. He was waiting to be hanged for murder, and Mr. Lampley had agreed to basically do work for him to obtain a pardon so that he wouldn't be hanged. And after being successful, Mr. Lampley wanted a fee. He wanted to be paid. It was £100, I believe, at that point. Um, but Mr. Braithwaite didn't pay him. And when Mr. Lampley sued him, he was successful in recovering that money. So even though arguably he'd carried out his consideration, so the service, before the agreement to be paid was made, the court held that the promise had been implied, so the agreement had been implied because he was carrying out a service. So I mean, solicitors don't really run into this type of issue anymore because typically, if you ask a solicitor to carry out work for you, they will send you an agreement first with their proposed cost and set out what they agree to do for you. You have to sign it before they do any work. So that doesn't really impact solicitors anymore. But you could see this could be an issue where, let's say, you call a plumber over because you've got a leaky tap or something. They do the work and then they ask for payment afterwards. And obviously, that hasn't been discussed before they do the work. You might argue that, well, you've carried out the consideration before the agreement was made. So you can see how there can be some difficulties in everyday life with this rule. The best thing to do is to discuss the work first and give an estimate of cost or something, and then carry out the work rather than do the work first. And I always wonder, how would the court stand with this if you are, if you have a friend who's a plumber and they come over, if they then want payment, what do the courts do? Would they say that, oh, this is a social domestic arrangement, the consideration was carried out before the agreement, or would they uphold it because they would deem that to be a service? So there are kind of grey areas there that give rise to some potential evaluation. The second exception is where a reward was always expected. So similar to the first exception, really, if we can see on the fact that perhaps the work carried out was always expected to be paid for or rewarded, even though that discussion hasn't happened, then the courts may imply that, if you like. So the courts can imply payment or uphold the agreement if they believe that that is fair to do so based on these potential exceptions here. Okay, then we look at our third potential issue with enforcing consideration. What do we do if the consideration counts within a pre-existing duty? And this, I think, gives rise to some evaluation, really. So I think nowadays job roles or the scope of job roles are really difficult to define. What counts as work within a pre-existing contract? If you go over and above your contractual duties, have you provided additional consideration for payment? Should you be paid overtime for that or be given a bonus payment or something? Does that count as work that would be, expected to be rewarded? So the original principle comes from the old cases all the time, of Stilk and Myrick. So Stilk was part of a crew of sailors with Myrick for £5 a month. When two crew members deserted the ship, Stilk agreed to do the extra work, sharing the wages saved. So of course Myrick, saved two lots of wages from the other crew members. But then when Myrick didn't pay Stilk for the extra work, Stilk brought an action, but the claim failed. And the court said that the extra consideration for his work was unenforceable because Stilk was performing his usual contractual duty to do everything possible in the event of emergencies. So we might feel that's a bit unfair. I know that in many jobs, there is a provision that if you do overtime, you will be paid for that. But there are, often jobs that we call vocations or professions, um, even in teaching, where you're expected to work extra hours, maybe work at home, um, attend parents' evenings, that kind of thing. And that wouldn't be seen as extra consideration for payment. That wouldn't be seen as, if you like, an added layer on your existing contract. It would just be deemed to be included in your contract of employment. So the courts wouldn't enforce that as additional consideration. There is a kind of exception which I feel has the potential to be quite wide. And what the courts say in Williams against Roffey Brothers is that if the duty provides an additional benefit, then this will count as consideration. So in this case, a carpenter was promised extra money, £10,000, to refurbish the flat. So they'd already been paid money to refurbish, but basically they ran out of money to pay to complete the contract, if you like. And because the defendant was going to be penalised for late completion, they decided to give the company an extra £10,000 in order to finish that contract so that they avoided the penalty. When they didn't pay that extra £10,000, they were sued, and it was deemed that they had to provide that extra money, even though you could argue, well, that was within the original contract, wasn't it, to finish the refurbishment. But what the court said was that this was a subsequent promise which allowed the promisor to avoid a detriment, so they held it was enforceable. So if you're looking at whether this is an issue in a scenario, then I guess the question is the promisor, or the person who's promised to pay the extra money, are they avoiding a detriment? And you could argue in Stilk and Myrick that Myrick was avoiding a detriment. They were avoiding having to pay extra wages to two other people. So, arguably, Williams and Roffey Brothers is a bit more fair. But we could always argue that if you do extra work, you are providing an additional benefit. So it is a bit unclear as to when that would be enforced. Okay, so looking at what if consideration is not fully performed but is only partly given. So, for example, if you partly pay off a debt, for example, would that be counted as full consideration and your contractual obligations discharged? So the general consensus is that if both parties agree to reduce the consideration, then that is fine. That would just be an amendment to the contract terms, and it would still be enforceable. What the courts want to do is make sure that contracts are fair and you're not being unfairly penalised. And also, they don't want promisors to go back on their promises if it's unfair to do so. So there's a kind of really landmark case, a really key case here, Central London Property Trust against High Trees House Limited. So this was during the Second World War, where obviously a lot of people were evacuated from central London. The owner of a block of flats in London agreed to reduce the rent, so by half, to the existing tenants, because obviously they didn't want to lose all of their money during that time, and it was difficult to find tenants. So some tenants obviously agreed, and they stayed in the flats, or at least agreed to pay the reduced rent through that time. But then after the war had ended, you note the date of the case, 1947, the landlord tried to claim full rent, which of course you could imagine is quite unfair. And the courts actually didn't allow him to. They said the promise could not be broken because the reduced consideration to the reduced rent in exchange for the tenant staying there was accepted. And the court stopped the party, the defendant, from going back on that. So in law, that's what we call promissory estoppel, if you ever heard of that. So the courts can stop parties from going back on their promise. Okay, what if we want to enforce consideration as a third party to an agreement. Under the original rules of privity, traditionally, only those that are party to a contract could enforce the terms. But we now have the Contracts Rights of Third Parties Act 1999, where third parties can enforce contractual terms as well and enforce payment if they can show that either they're named in the contract or identifiable in the contract or intended to benefit from the terms. So if we look at, and this actually does come back to old cases again, Shadwell and Shadwell, 1840, the uncle said to the nephew, if you agree to marry your fiancée, I'll pay you £150 a year until your income as a barrister reaches 600 guineas. So he died after making 12 instalments of this, and the nephew sued him for the remainder, or his estate rather. And this contract was held enforceable, even though a third party was involved in that. Okay, so the consideration must be given from the party that was intended to benefit, otherwise it would be considered as a gift. So we do have to look at what did that third party give. So obviously in Shadwell, they're working as a barrister, they're agreeing to marry, so they're giving something there. You could argue, is that of sufficient value? But of course, in that case, they held that it was, and he was able to enforce that contract there. Please do have a look at the case of Tweddle and Atkinson. It might provide you with an alternative perspective to that, where consideration was not given. Okay, so I have a summary slide here with you for those key points. So the reason why I've set the consideration elements out like this is because when you look at scenarios, often issues will be raised in this way. So typical scenario issues would be around whether there is actual value to the consideration, the timing, and pre-existing duties. Those three I see quite commonly, and if you've already been looking back at past paper scenarios, you will see those as well. But of course, remember, reduced consideration can be accepted, and you can enforce consideration as a third party as well. So remember those two additional areas just in case they come up. So let's have a look at some application then, so you can see how this might work. So a typical structure I would give you would be this. So focus on the relevant issues in the scenario, list or explain the AO1 first and then apply. But of course, because consideration is a bigger area, really we want to focus on the relevant issues. So if you can, read the scenario first and decide out of the 5 areas which ones are you being assessed on, and then write about those. So your answer doesn't have to be really lengthy. It is about relevance. So you could give an intro sentence first about what consideration is, and then use these parts out of the 5 to apply and explain. Okay, so once you've written those down, we'll move on to the next slide. Okay, so have a read of this scenario. The question here is whether Lucy or Sarah have given good consideration for Danny's promises. In other words, can they uphold Danny's promise of extra payment to both of them? Have they provided good consideration over and above their existing duties for his promise? So we've got kind of 2 sections to our answer here. We've got Lucy and Danny, and then Sarah and Danny. So have a read of that and then decide what you think the issues are, and I'll go through it with you. So please do pause here. Okay, so Lucy and Danny. So this is about whether Lucy's additional work fits within her pre-existing duty, or whether she comes under the exception of providing an additional benefit. So the Stilken-Myrick and the Williams cases are relevant here, and hopefully you spotted that. So I've set out how I would answer this in terms of application. So the usual consideration here is Lucy's role, providing a service as a waiter in return for Danny paying her wages. And the value here in question is the exchange of Lucy picking up Bill's work while he is off for the promise of a bonus. Okay, so this is considerable value. There's no question over the value, is there? This is work in exchange for money. On the face of it, though, Lucy's promise is not valid consideration because she is working within her pre-existing duties. So it's not unusual for a waiter to pick up work if a colleague is absent, like in Stilk and Merrick. However, given that Lucy's extra work avoids the need for Danny to hire extra staff, so she, in the scenario it says she works extra hard and provides a good service to customers, she may be able to enforce the payment because she has provided him with an additional benefit. So therefore we can conclude the consideration may be enforceable here. Okay, so let's look at Sarah. So the value for Sarah is bringing the flowers into the restaurant whilst Bill is unwell for Danny. There's an issue of timing here instead because Sarah's made the deliveries before the promise of payment, like the Rima Cardle case. So this may not be legally enforceable. So usually, remember, consideration under a contract is enforceable when the agreement is made before the contract is performed. But could we argue that payment would be implied? So Sarah potentially could enforce payment if she can argue she was performing a service and therefore payment was expected, or perhaps a reward would be expected. I would argue this would be more unlikely given that she offered to make the deliveries in addition to her role as a florist. You wouldn't usually expect that. So this would perhaps on the face of it be unenforceable. What I always say to my students is, if you believe that the conclusion would be different, you wouldn't lose marks for that. You have marks for reaching a reasoned conclusion. So as long as you back it up with the correct legal principles, it's fine. Okay, so let's have a look at the main kind of evaluation points for a potential consideration essay. As I said, this came up in 2022 as an essay, so you can have a look at that question and the mark scheme as well for potential points. And I set them out again, points 1 to 5. I would start by talking about, and you can structure this in the same way as the AO1, which kind of helps. The meaning of value, so obviously minimal value. Could this be exploited by businesses to make sure a contract is enforced? In terms of unquantifiable values of contracts, is this always going to be consistent and clear? Obviously, we've got Ward and Byron versus White and Blewett. In one, love and affection was clearly consideration. In the other, a son's promise to his father for not complaining was not sufficient. Secondly, is it unfair that the courts limit the enforcement of past consideration, especially if there has been an agreement afterwards to pay? Was the Rima Cardle decision fair? Potentially not, because of course the siblings will profit from the improvements that she's made to the bungalow eventually. So surely she should be paid for that. Thirdly, is it always clear when payment is implied by nature of service? I think I mentioned this before. What if the parties are friends? You know, what if you ask a plumber to come and do some work for you and they're a friend and you don't discuss payment until afterwards? Would the courts be willing to uphold that, or does intent also become a factor there? Fourthly, is the pre-existing duty principle outdated? With an increase in flexibility of work now, many people work from home. The scope of roles are actually difficult to define. And in vocations or professions like teachers, doctors, people who own their own businesses and have staff, it can be difficult to define what is within a contractual duty list. So arguably the Williams principle of additional benefit could apply to any situation. If anybody goes above and beyond or carries out extra work, surely that is providing a benefit. But the courts were quite clear in Williams that they will look at the detriment that somebody would suffer by that work not being carried out. But still, we have a lack of clarity there, I would argue. And then fifthly, the rule on enforcing agreements on part consideration is fair, protects parties' rights, as we see in the High Trees House case. Obviously, it was fair to stop the landlord from going back on his original promise to reduce the rent. And of course, we could say the rule on allowing third parties to enforce consideration where intended is also fair, because if you're named under a contract and you're set to benefit from it, then you should be able to enforce it. And don't forget, we have the Contract Rights of Third Parties Act now that legislatively protects third parties in 1999. So that's the kind of move in the right direction. Remember, many of these principles are based on old cases. So reform-wise, we could argue, let's update those, let's put them in a piece of legislation. Okay, so I hope that helps. Thank you very much for listening. Keep your eyes peeled for a third session, which will be on terms. Thank you very much.